Morning, sir. Thank you for coming. Did you submit written testimony?
I believe there was testimony.
Okay, thank you. Whenever you're ready.
Thank you. Members of the task force, my name is Aaron Wenzloff, and I'm a staff attorney at New Haven Legal Assistance Association, where I represent low-income clients in family cases. I'm going to be talking today about the role of the guardian ad litem, as well as Connecticut General Statute 46B56. In our family cases, we prioritize representing victims of domestic violence, many of whom have young children. These are tough cases, and the assistance of a guardian ad litem or an attorney for the minor child is often indispensable. On the whole, the legal services community feels that the GAL system is important and valuable for our client population. At the same time, the system for appointing GALs could be improved. Most parents who enter the family court don't know what to expect from a GAL. Providing plain language information to parents would help them understand the role of the GAL and how to work with a GAL for a successful resolution of their case. Second, there's no set of professional standards in Connecticut that describes what GALs are supposed to do if they're doing a good job. Other states, for example Massachusetts, do have official written standards describing professional conduct. Connecticut should do the same, so there are guidelines about what constitutes competent ethical conduct. Additionally, family courts are sometimes inconsistent in how judges give direction to GALs. Sometimes a judge's order will be very detailed about the GAL's role, but many times the order is vague or incomplete. Providing very specific details in the judge's order about the scope and purpose of the GAL's investigation, as well as the details about payment, who pays at what rate, state payments, those sorts of things, would ensure that the parties in the GAL understand the relationship at the outset, and there's no unwelcome surprises at the end of the case. The judicial branch could create a checklist order form to make it easy for judges to specify the details of the appointment and not forget or leave something out that's really crucial for the parties in the GAL to understand. Also, there is no way for parents to provide feedback about the performance of a GAL in their case. Creating a way for parties to provide an evaluation of a GAL in a questionnaire at the completion of a case or a hearing would gather information about the performance of our GAL system here in Connecticut so that further improvements could be based on system-wide data and evidence, not just anecdotes. Finally, turning to Connecticut General Statute 46B56, the legal services community believes that judges evaluate cases holistically when making and enforcing custody and visitation orders. That really is the only workable and appropriate approach to family cases, particularly for our most challenging cases involving struggling parents and a history of domestic violence. The current statute includes 16 non-exclusive factors for the court to consider. No factor weighs any more than any other. That's the right approach. Every case is different, and therefore the court needs to take into account the entire picture that each family faces with the ultimate focus on the best interest of the child. We hope that there will be no changes to the statute that might upset the careful balance that we have right now. Thank you.
Any questions from the task force members? Fair enough.
Go ahead.
Hi. The statutes that you were talking about, the 16, and the fact that the judges can weigh one more than the other, that's one thing that I've kind of had a problem with, because I think those statutes are really, really important. And I don't know how you feel, but looking at all 16 of them, being able to check off and then kind of have a percentage of some sort saying, okay, so 12 of the 16 are a problem. I mean, I don't know, do you know much about how they are looking at that? Because I know the language of it is that they don't have to weigh any one more than the other, but each one that's in there, in my opinion, is very important. So whoever put that together did a really good job, because that really is the best interest of the child. All of them, not half of them, not two of them. What's your thoughts on that?
So if I understand your question correctly, you're curious how judges make decisions about custody based on those factors?
No, I kind of understand how they do it. They can correct me if I'm wrong, they can weigh any one of those 16 factors, or they could not look at any of them. One of those factors could be the reason why change happens regarding that family. But I think every single one of them needs to be addressed, because the mere fact that all 16 made this list, they all should be, when a judge goes ahead and gives their reason for whatever it is, it's kind of a check and balance. Okay, so number 1 through 16, what's not happening here? Because we know the best interest of the child is every 16 of those. And I don't understand the concept that let's weigh maybe 5% on one of them, maybe 50% on the other, maybe 0 on another. Like, do you understand does anyone understand what I'm asking?
Yeah, so in response to that, I think in general, my experience has been that judges, I believe, look at all of those factors and make some sort of determination about what is the best outcome for this family and this child after evaluating the entire picture that the family is facing. I think it's difficult for a judge to put percentages on factors. I don't know if they do or not. You'd have to really direct that question to judges. But the cases that we face in legal services are often very complicated with numerous barriers for both parents. Children might have medical issues. There might be all kinds of things going on with a family. So looking through all of those factors is really key. And as an advocate for parents and victims of domestic violence in family cases, we look at those factors very closely to try to muster the best evidence we can for what we think is the best outcome, and work with guardians ad litem and attorneys for the minor child to ensure that they understand what factors might be at play for this family and which ones might not be. Not all the factors always apply. Sometimes they all do. Sometimes only a handful do. It's really case by case. And I think in general our judges do a really good job in family court of most of the time looking at those factors. They might not say exactly how they weigh each factor, but I think they really do look at all the factors.
My last comment on that, when I hear the word weighing, that tells me that they're applying a percentage. They're weighing, because in statute it says they can weigh these different factors. So maybe it would be a good idea to have all 16 listed with apply. Does it apply in this case? No, because I think everyone should know what the judge is thinking when they're making their determination. So I don't know if that makes sense to your organization, but it would be nice to know, here's the 16. Maybe 5 apply, the others do not, and I don't know, I'm just...
Yeah, I think sometimes judges write decisions that articulate the basis of the determination that they've made. Other times they leave it more open-ended. It varies from judge to judge. The statute, as far as my recollection is that it says no factor weighs any more than any other. And so given the complex dynamics of families going through divorce, it is really a holistic determination that has to be made. And I'm hopeful, it's been my experience, the judges I've dealt with, I think, make that holistic determination.
First, Mr. Weissmuller, and then Representative Gonzalez.
Thank you. Mr. Wenzloff, I'm not sure if I understood your testimony correctly. Did you mean that it's a holistic process or a holistic determination? Because I think you said both.
Well, so the statute currently lists 16 non-exclusive factors. I think in some cases all of them apply. In some cases only a handful apply. It's a really, family court decisions are a factual determination. Mm-hmm. So from the legal services perspective, we think that the statute very artfully spells out all of those factors. And I think we don't want to elevate one in a mechanical kind of formulaic way so that judges focus exclusively on one out of the 16 factors above the others.
Okay. My view of the process is it's adversarial in nature, and the two parties are coming in trying to compete, if you will, almost like they're competing for time. Obviously, they have difference of opinion. They're not getting along. the judge is entertaining this in a trial process. So I'm not fully understanding how you're marrying the concepts of the adversarial process with a holistic response, unless you're just speaking to the statute itself as asking the judge to try and come up with a holistic remedy to an adversarial process. Is that what you mean?
I think that's what I'm getting at, is that the statute as written really captures a wide range of factors, and we think that wide range of factors often should be looked at in family cases.
One of the things that makes a family case complicated is it's very easy to turn it into something that's very, very broad and complex. The fact of the matter is you've got two parents that are maybe not functioning well together as a team, but you have established relationships between the child or children and each parent. And it seems as though what we're seeing in a lot of the testimony that we've received and prior to this is that that process is immediately disrupted. That relationship is immediately disrupted based on the trial process. And the trial process appears to be quite long, and so it takes quite a bit of time. If someone's going to rely on the trial itself, that trial might be a year, 2 years down the road from the initial filing. And so we're not really seeing that the process is in any way holistic. And by the time you actually are getting in there to try and define the elements of your claim, so to speak, as an attorney would do when you're trying to establish the preponderance of the evidence in favor of your side, it seems as though you're asking to prove each element is, or at least more of them are on your side than the other side, and it's doing nothing to bring the two parties together. I mean, the statute asks you to basically prove that you're the better parent as opposed to establish what will work best for your child. And quite frequently in the adversarial process, each person's kind of tugging on the child as opposed to trying to say how sharing time in some way versus another way is better. And if they're really only talking about sharing time in one way versus another way, why would you take 18 months to do that and have the relationship between the children and the parents disrupted for that time until you can get to a trial?
Is there a question you want me to respond to?
Yes.
In particular?
That last part, if it's holistic, why this process, you're saying don't change it.
I'm sorry, I didn't mean to be rude in that comment. I guess what I would say is, in my experience, most cases don't go to trial. Very few cases actually end up in a hearing in front of a judge, because in most cases, through the parties working together, or often in my case, working with other attorneys or working with the other party, we can come up with some sort of resolution along the way about visitation, custody, those sorts of issues outside of trial or hearing process. I think it's important that the statute spells out a long list of things that judges should consider or might consider. And all of those things are often relevant in family cases. And that, I think, provides a lodestar for advocates and parties when they're in court. Many of them are common sense sort of factors: the temperament of the child, the developmental needs of the children. Those sorts of factors, it's hard to, you're not actually proving necessarily an element, a legal element in the sense you might in a, for example, a personal injury case, you have to prove the element of negligence. In a family case, you just have to, I think, keep your mind focused on all of these factors that might play out in kids' lives in the context of a divorce. And so I think it's important the statute spells those out, and that judges have that in the back of their mind, and you know if you eventually go to a hearing, which most cases don't, or a trial, most cases don't, that those are the things that are really guiding the entire process, is that whole 16 factors.
Well, now the interesting thing that you just referenced is that those things guide the entire process and that really you're avoiding a trial. In fact, in a trial, there are burdens of proof. There are things to be established by the preponderance of the evidence, and the ruling can only be based on factual findings. I mean, that is the case of a trial. So it sounds like you're trying to say that maybe the trial is not the best process.
Well, every case is different. Some cases, a trial is what ends up happening. Other cases, in fact, the majority of cases, they fall well short of trial because the parties can work out resolutions ahead of time. I mean, in general, if one were to generalize about how an ideal family case would work, it would be less adversarial, and the parties would come to resolutions that work for everyone, and including the child, of course, along the way. I understand, it's a legal context, so there are burdens of proof if a trial happens, but there's a lot of opportunity to resolve cases well before you get to that stage.
May I just ask a question, Dr. Horwitz? I'm intrigued with your suggestion that it would be helpful to have a set of professional standards for GALs, and I'm wondering if you can get us some samples that you've discovered. You mentioned there's such a thing in Massachusetts. And then just beyond that, how to evaluate, if someone's starting off as a GAL and they're trying to follow these guidelines and they're a novice and they're not that good at it yet, are you aware of other states having a mechanism for helping GALs to improve their skill or to enhance their technique? The only kind of evaluation you recommend so far is feedback from the parties in a case about how their GAL did, and that sounds like a possible idea. But what about a more sort of professional assessment of how colleagues are doing?
So with respect to the standards, just based on some limited research I did, I know Massachusetts, for example, does have official promulgated standards for GALs, but bear in mind, GALs in Massachusetts are not exactly the same as GALs in Connecticut.
I understand they're very rarely attorneys, actually. They're most often mental health professionals.
And they serve, according to my understanding, now I'm not a Massachusetts attorney, my understanding is that they serve almost exclusively in an investigative role. There's not an advocacy role or a mediation role. And in Connecticut, we're much, I think the definition of a GAL is somewhat more capacious in terms of the roles that they might approach in a Connecticut case. But I found the standards that they're available online, and I can certainly send you a link via email or something of that nature, are quite comprehensive and I think useful in thinking about what would help guide GALs and frame the expectations for GALs about what is good professional conduct. I don't know if other states have continuing education programs. I suspect some do, but it seems like it would be a good idea because we do now have a training program for GALs in Connecticut. It is, I think, an important prerequisite to being a GAL, but after you've taken that course, at this time, I don't believe there's any requirement that you have continuing education or refreshment of your knowledge about child development or things like that. So I think continuing education could be a really useful component to improving our system.
I know in Massachusetts there's a professional association of GALs that goes by the amusing acronym MAGL, Massachusetts GAL, and they have meetings every year and speakers, and I just don't know if there's a sort of a mentor program or a supervision process that's in place for
I don't know.
Okay, thanks.
Yeah.
Representative Gonzalez.
Yeah. Thank you, Madam Chair. And thank you for coming. When you said we hope no changes to the statute, can you explain what do you mean we?
The Legal Services Community.
The Legal Services Committee. And do you think that all those state statutes are being followed by the judge? All of them?
Well, it would be my hope that judges apply the law correctly. I mean, as one might imagine, sometimes judges get the law wrong. I think it's on a case-by-case basis. I think that's in some sense an impossible question to answer because the law is constantly in flux and cases. This is why we have an appellate division and a Supreme Court in Connecticut. There's a mechanism for challenging things that don't turn out the way they're supposed to according to the law.
Because when I asked the question because you said very clear, we hope no changes. So, in other words, my understanding that you really believe that the judges are following those state statutes when you say we hope. And my thing here, my comment to this is that if they are following those state statutes, then why we have so many problems and so many complaints, and why you got families and they came and complain about what's going on, the way they've been stalling cases, children's abuse and all of that. If they are following those state statutes, then my question is why we have so many changes. So do we have to be sure that the judges are going to enforce the state statute and they will go by the law, not by what they want, because what they have to go by, because something is wrong here. If they are following those 16 state statutes and we have thousands and thousands of complaints, so something is wrong there. In your opinion, now that you said that we hope no changes, in your opinion, tell me, what do you think that we should do just try to avoid and fix the problems? Tell me in your words.
Well, I think there's a distinction between the substance of the statute and the enforcement of the statute, or the application of the statute by individual judges. The substance of the statute is totally appropriate in terms of what factors are listed and how those factors are described. In terms of the application of the statute, I think it really is an individual case-by-case analysis. I can't speak to how judges across the state of Connecticut are deciding these cases. I have an individual caseload, and I have a sense of how cases are decided for my clients and maybe the attorneys I know, but I don't practice across the state, and I don't have a comprehensive set of evidence about how the applications are being made, how the application of the statute is being made in individual cases. So I really can't answer as to that issue.
So if it isn't the best interest of all child, I think that instead of saying we hope no changes, maybe you can say we hope that we can do something so judges can enforce this and go by the state statute. Thank you.
Mr. Gitano.
Good morning. Thank you for appearing today. Appreciate it.
Excuse us. Given the fact that there are so many people here waiting to speak,
Excuse me.
could we respectfully ask that the testimony be limited to 3 minutes as publicized, because there are so many parents here. We've already suffered enough. We have responsibilities to our children and our families, and if we allow everyone to speak for half an hour...
Sir, you are out of order. The testimony is limited to 3 minutes, but the task force members get to ask questions, and that is what they are doing. They are asking questions. Sir, you are out of order. Please. Sir. No, it's...
Once again, we're not hearing from the parents.
Sir.
That's why we're here.
You are out of line and out of order. Please, excuse me.
Point of order. And let's limit the questions to 2 minutes or 3 minutes.
We all want to speak. We all have...
And everyone will get a chance to speak. Sir, you are out of order. Please sit down and wait your turn. We are going in order. The task force members are asking questions. That is their right to ask questions. Sir, please. Well, each task force member gets to ask the questions they want.
Madam Chair,
Yes.
perhaps we can ask the task force members, to limit their questions and expedite their questions, because I think that asking the same question 20 ways, you're not going to get a different response.
Well, I agree, and we had discussed this at the beginning. I had made a suggestion that if answers were approaching 15 minutes because of the number of witnesses we have, that we would ask that person be excused, and if they wanted to come back and answer questions later, they could do that. But I got some pushback from certain members of the task force, so they're indicating that, and maybe we can let Representative Gonzalez speak to this, because she says that they get to ask their questions. So, I'm just following the protocol.
And I will say that the process here is you come here, you give your testimony, and then as members of the task force, we ask questions, because if we're trying to find solutions to the problem, we have to ask questions. But if anyone here got a problem, I think that maybe we can, maybe with the chairs, maybe we can talk, and maybe we can see if we can work something out. They are members, they are people here, they want to testify, they don't have a problem waiting all day. But we know there are people here that have to go to work. If that's the problem, maybe we can discuss this with both chairs, and maybe we can come up with a solution.
And I would like to say that we did discuss it, and we had agreed that in 2 hours, we're going to go through this process, and then we're going to have a little break, and then we're going to reevaluate it. So if everyone could just be patient, we want to try to do the best we can. So I just want to put that out there.
At the current rate, we'll only see 12 people by 5 o'clock. And I'd like to continue the public hearing until everyone's heard. State officials instead of parents.
Yes.
Excuse me, this is not how this works. If people are out of order, we're going to ask the Capitol Police to remove them from the room. So if you'd like to stay, you're going to have to follow the protocol. Thank you.
And I would like to hear a little bit more from him, if it's 2 more minutes, and then we end it. But we all have the right to ask questions.
It's either all or nothing, or if we're not going to ask questions, we'll just move on.
Joe, before you jump in, Al, you're timing, are you not?
I am.
Okay. How much time have we devoted to this speaker?
We have used 26 minutes and 18 seconds.
All right, Joe. So what, Joe, and I apologize. What we're going to do here is, at this point, Attorney Wenzloff, I'm going to make 2 suggestions here, absolutely in deference to the folks who have signed up and are waiting to speak. At this point, I think that what we need to do here is move on to our next speaker, and perhaps if there are other questions directly for Attorney Wenzloff, perhaps that can be addressed out in the hallway, if individual members want to talk to him out in the hallway, and Representative Vargas.
Just a quick question, because I don't want to prolong the process. I listened to the exchange between our task force members and you. You're not saying that you'd be against supervision evaluation of GALs in any way. It seems you almost imply in your testimony that you'd be in favor of getting feedback from the process.
Absolutely. I mean, I think my written testimony captures the recommendations that we make with respect to evaluating GALs.
Okay, I think that really was the upshot of people's concern when they were asking you, are you in favor of the status quo? And I think that you made it clear in your testimony you'd be in favor of an evaluation supervisor.
Absolutely in favor of some possible changes that we have.
And I apologize to the parents out in the audience, but I think that because he is representing legal services, which does half of the work with the GALs, people really wanted to know what the position of this particular organization was. Thank you for your testimony.
And as a chair, I'll just ask the task force members to be sensitive to the amount of time that we're spending with each of these people. We have 59 people signed up so far, and there may be more. So if we could be sensitive to the amount of questioning that's going on, I think sometimes we're having multiple questions asked over and over again. If we could please be sensitive to that, it would really be appreciated. Thank you.
And I would just ask, as a member of the task force, to think about your questions. I mean, grilling someone about what judges do, and that's not his role. And people are not going to want to get in the hot seat for 26 minutes.
We hope.
Let's move on.
Thank you very much.
Thank you.
Thank you.
Next, we have Shirley